Hello everybody, this is Mike Seifert coming at you with another video. Today we're going to talk about writing up a purchase agreement. This is a training video for agents and or individuals looking to purchase a house. So individuals meaning investors, a for sale by owner, somebody that is in need of understanding how a purchase agreement works. There are some other documents to make an offer, but today we're just specifically talking about the purchase agreement. So let's begin. So we're going to use a standardized form through GMAR, which is a board over in Michigan. And we tend to use the standardized purchase agreement because it's easy for people to understand. It's more generic. Now, some other agencies out there, the bigger ones like RE/MAX, Keller Williams, etc., they may have their own clauses in the purchase agreement, their own customized ones. So just be careful to read everything in the PA. PA stands for purchase agreement. I will use that term. Be careful when you're writing or reviewing a PA. Make sure you read all the clauses because they sometimes sneak additional information in there besides the standardized clauses. So let's begin. So let's say you're an agent or just an individual. We're going to talk about what's on this. So up at the top, we have what is the MLS number, which stands for Multiple Listing Service. If you're an agent, you understand what this means. For somebody that may not, this is a number that's on a listing ticket through the MLS, which in our case is called RealComp. So the MLS, every listing has a number. That's where that goes, that number, so we know which listing we're talking about. On the right-hand side here, we have the date, November 2nd, 2018. And this is mostly self-explanatory, this middle part. The listing broker, obviously our company would be, let's pretend for a moment, New Michigan Realty, my name. This is my ID number with the MLS board and our office ID number. And then, of course, my email. Over here, you would put the selling broker. So let's just say it was us or it was a RE/MAX. You would put RE/MAX in the Shores, let's say, if that was the name of the company. The selling agent, could be, let's just say Betty Smith. And then you get the picture, etc. We would put their ID and everything else. So let's go to the property description. The undersigned buyer hereby offers and agrees to purchase property located in Michigan City, Township, Village of, and we're using the city of Berkeley as an example, County of Oakland. The tax ID number will be a ID number with the county and the city, indicating exactly which parcel it is. So it's very important to have the correct ID number. Now, if you're an agent and you're under RealComp, there's a thing called Transaction Desk that will automatically populate this information for you. But for the individual investor, you want to make sure that you have this tax ID number correct, along with the legal description. Maple Lane Subdivision, Lot 77, for example. However, some legal descriptions are very long, and you don't necessarily need the entire legal description. North 22 feet of lot, 88, east 22 feet. Basically, if you can get the subdivision with the lot number, that's pretty much going to be okay. Unless it's an odd type of legal description, you just want to get as much detail as you can fit in here. So there's only so many characters you can put in here. In this case, we're doing a simple, let's say, ranch house. And we're just going to say it's on in the Maple Lane Subdivision, Lot 77, commonly known as, this will be the actual street number, Smith Street, 7727, zip code for Berkeley is 48072. Property described above shall include all available subsurface and mineral rights, all fixtures, improvements, and appurtenances now in or on property. If I mispronounced that word, excuse me. Including all built-in appliances / equipment, shelving cabinets, all lighting, fixtures, ceiling fans, attached carpeting, all window treatments and hardware, attached mirrors, hardwired telephone system, and you can read the rest and see. So let's talk about this. On a listing ticket, if the listing ticket is offering the refrigerator, the stove, washer and dryer, and any special things such as, like, let's pretend there's an attached bench in the concrete, or it could be removed though. You want to make sure to put that on the purchase agreement. If it is not on the purchase agreement, it does not exist. This purchase agreement is the only thing that counts in real estate in the end. As an agent or individual investor, you always have to think about what are the consequences in court. You always have to think about the worst case scenario. What will happen in court if I don't have the correct paperwork done? So we're always looking at the worst case scenario. In this case, we make sure that we write all this stuff down. If you get to the end of a transaction and you forget to put in the refrigerator and they take it out of the house and your buyer wants that refrigerator, was expecting it, guess who's going to pay for it? Usually the agent's it's going to have to come out of someone's pocket. So, or there's errors and omissions insurance as well for that. But unfortunately, we've never had a problem here at New Michigan Realty with that. But you want to just make sure it's in here. So number 2, price. Buyer agrees to pay the sum of $250,000 in consideration for which seller will provide a warranty deed subject to existing building and use restrictions and easements and rights of way of record. So that's pretty self-explanatory. You're putting in the price. The payment method, and here we have a cash sale with new mortgage and a land contract. Now, for this example, we're going to pretend it's a conventional mortgage. So right here, you're going to actually put in conventional mortgage, VA mortgage, which is Veterans Association mortgage. That is, veterans loan is easier to get for veterans. And they should be very entitled to this. They, fought for our country, and some of them risked a lot of injury. So the VA mortgage is awesome for veterans, and they don't have to put a down payment, and it's a lot easier to get into a house. So thank goodness for that. FHA, which is Federal Housing Administration, that is a program where you can put as little down as 3.5% down, and there's requirements as low as I believe a 580 credit score to get into a property. So anyhow, in the amount of $250,000, paying $25,000 down plus mortgage costs, prepaid items, adjustments, and flood insurance if required by lender. When you put down the down payment, just make sure you put down the correct mathematical percentage. You don't want to look unprofessional. If it's 10% down, make sure you put the correct 25% down. That's in here. Don't be lazy if you're like, whatever, I'm just going to put anything in there. You want to put the correct numbers because it looks professional when everything's done correctly, and your credibility goes up when everything's pretty much done right. Buyer agrees to apply for such mortgage at buyer's own expense. In the real estate business, industry standards, we usually use 3 calendar days. So basically, if you're a buyer's agent, or if you're working with somebody that is not already pre-approved for a mortgage, that's not good. You want to definitely screen your buyer, and we'll talk about that in another video. So really, they're not going to apply for a mortgage. They've already, in most cases, already applied. But if they haven't, they're agreeing to apply within 3 calendar days here. Sometimes it's 2 calendar days. But our company usually does 3 days. If the mortgage commitment conditioned only upon a marketable title and satisfactory survey, if required, is not delivered to the listing broker within 30 calendar days from the date of this agreement, the seller may declare agreement void. So what that means is that from the date of this purchase agreement, 11/2, excuse me, that's incorrect. We're going to talk about how much time you have on page 5 of this. So 30 days. 30 days from the final signature of either what's known as the bottom line from the buyer or from the seller's signature line. Now, there's a little bit of an argument going on, or debate, I should say, in the real estate industry that once the seller signs the second signature and accepts your offer, that's binding, which is correct. It is binding. But there's a debate whether the bottom line signature can be used for your inspections in this 30 days that we're going to talk about. So you have to determine what signature line you're going to use. Our company typically uses the bottom line signature, and I will explain more details about the bottom line signature when we get to page 5. So that's where 30 days is going to come in, from when the final when the seller accepts your agreement. There's going to be 30 days from a certain day to close. So let's see here. So marketable title. Another thing I want to mention, marketable title. What that means is that the seller has the ability to sell the property, that there's no liens on the property, that their best knowledge, it's marketable. the chain of title is not messed up where somebody made a mistake 3 sellers ago and the chain of title is not correct, and the title company can't issue a title insurance policy, and we'll explain more later on that. But the title has to be marketable. So if you have a person that's selling a house and pretty much they are on time with their mortgage payments, there's no liens, it's a perfect home, there's no problems, no contractors have a lien from doing repairs, it's a pretty marketable title. So that's what that means. Earnest money deposit. I can't stress enough how important this is for agents to turn in your earnest money deposit on time. So buyers depositing with broker, in this example, $2,500 in the form of a check, money order, etc. An additional sum, usually we don't require an additional sum. It's usually we go with the first line of $2,500. And just for sake of Michigan law, we just say 2 calendar days here. So the total earnest money deposit will be $2,500. Now, let me go back to this calendar day thing, because a lot of agents are confused about this. At least in the state of Michigan, an earnest money deposit needs to be deposited. That means sent into the broker and deposited within 2 banking days, not 2 calendar days. This is something different we're talking about here on this line. Not 2 calendar days, not 2 business days, 2 banking days. So let's say Columbus Day was one of the latest holidays, I think. That was on a Monday, I believe. So if you get an earnest money deposit on Friday at 2 p.m., technically speaking, you'll have to Wednesday at 2 p.m. or 5 p.m. in most cases. As long as you get the funds in a reasonable time frame, that is good. Now, what happens is if you don't deposit that and the transaction falls apart, and you're saying that you received it, in some cases the seller may come back after you or the brokerage for that money. And if you're dishonest and something happens or you forget to deposit it, if the money's not secured, the buyer's not going to say, here's $2,500. They're going to say, no, I'm not giving you $2,500. So that check needs to be cashed right away. It must be. So agents collect the check, make a copy of it because you'll need that for your offer, and submit it to your broker within 2 banking days. It's very important. Acknowledgement down here, received by New Michigan Realty. Let's say your name. Now the signature again. If you sign this and you don't have a physical check in your hand or the cash, you're putting yourself in liability. Do not sign this until you have a check in your hand. Don't say you received something when you don't. Some agents just say, hey, whatever, it's not a big deal. He'll give me the money. Well, if something happens, money changes people. And if that happens and the seller wants that earnest money deposit because something happens, somebody's going to be on the hook for that $2,500. And usually it's going to be the broker first who's responsible, and secondly, the agent. So there's going to be some type of claim, errors and omissions insurance-wise. So it's never happened at our firm, but there's always a first. So just be careful on that. And what is the EMD? The EMD is just a good faith deposit that states that I'm serious. It's usually 1 to 3% of the purchase price. So if it's a $250,000 home, we're doing 1% here. If you want to show more seriousness, you'll maybe do 2 or 3%. I've seen them as high as 5%, or it's like, a $15,000 EMD, which is not necessary. So $2,500 to $3,000 in this case is good. Closing, subject to all conditions herein. Closing shall take place on or before November 3rd. So our purchase agreements written up for November 2nd. And excuse me, I said November 3rd. I meant December 3rd. So typically it's 30 days out from the time of acceptance. We always want to go at least 30 days unless it's an FHA or government loan. Sometimes that can take 45 days. So if it's a government loan, VA, FHA, sometimes we might put in here like 12/15/2018. So that gives us ample amount of time to receive to get the financing completed with the bank. So the buyer will initial here, and of course when you submit, the seller will initial here. So that's just page 1. Number 7, possession. This is very important to pay attention, especially if you're an agent. Please calculate the sum of per day, the amount per day they're gonna pay in rent. So here's how this works. Seller shall deliver possession to the buyer sometimes at closing, which is right here. If it's a vacant home, they can get it right away. Sometimes the homeowner might say, hey, I need 30 days to get out of the house. So if it's 30 days, now the buyer is going to purchase the home, but the seller is going to still be there for 30 days. So you're going to say, you might be saying to yourself, well, who's going to pay my mortgage payment? Well, the seller is. At the closing, the title company will hold an escrow 1.5 times the amount of money that is required. Now, how do they come up with that number? Well, that is calculated by taking your mortgage, your buyer's mortgage, say in this case it's $1,500 a month. You're going to go on like a Google here. We're going to go on to Google, and we're simply going to type in mortgage calculator. And on a $200,000 home, you're just going to quickly put that in. With interest rates now are like 4.5% or so, 30 years. So your payment's roughly $1,013 a month. So what you're going to do is take $1,013 and you're going to add your taxes in there. Whatever. Let's say the taxes are another $200 a month. You're going to add that. The insurance policy. Remember, they're going to have to pay insurance. That might be another $70 a month. We're going to add that. And we want to make sure we overcompensate. So we're conservative. So we add additional numbers in there. Just, if the policy is only $50 a month for the insurance, we put $70 just in case. We want to be absolutely sure. Maybe there's PMI. If they're putting 10% down, I believe 20% eliminates PMI. That's primary mortgage insurance. So we're going to add another 120 in there. I'm not sure what that is exactly, but so we're at about $1,400 a month. So we're going to take exactly $1,403 and divide that by 30 days. So that comes up to about $47 a day. We're going to round it up. It's $46.76. We're going to round it to $47. So now we have $47 a day. So if the buyer stays in there, the seller stays in the home only 15 days after closing, they're going to owe 47 times 15, which is $700 to the buyer for that. And then they'll pay their mortgage. So it's called rent, and it's a per day. So that's very important, especially for agents, to calculate the correct amount of money per day. Because if you're short on this at closing and you don't do this right, someone's going to pay. Either by having a bad review, your client's going to be really mad because you shorted them if they're trusting you and they don't check this. Or you're going to end up paying this yourself. They're going to ask for that money. Somebody's going to pay, and it's not going to be the client. I can tell you that. So, and this gets held in the designated escrow agent, usually the title company, 1.5 times the daily fee. So they might collect, actually they're going to collect 47 times 1.5, $70 a day times 30. So $2,100. So the title company at closing will hold $2,100 out of the proceeds from the seller. So the seller's proceeds, let's say they owed money on the house, they netted $10,000. Out of $10,000, they're going to take out $2,100. So there's going to be a check issued for $8,000 at closing to the seller, and $2,100 is going to be an escrow until they move out. And then that escrow will be subtracted per day, however many days the buyer or the seller stays in the home until they move out. If they take the full 30 days, then the entire $2,100 will be issued to the buyer. And yes, that's correct, to the buyer, so they can pay their mortgage. And that will be done through some type of addendum signing off that they moved out, and there's a couple different ways of doing that. You can sign an addendum, or there could be an email, as long as it's in writing that they moved out, the keys surrendered, release our funds. So you could read the rest of this under possession and go from there. Availability of home protection plans. We have a couple home warranty companies. America's Preferred, and then there's another one I forgot that we use. So I'll just find out the best one that works. Sewer and water charges. If it's a vacant home, you're going to click to closing, meaning that the water is going to be paid up to the date of closing or the date of possession. So the title company will hold another $300 out of the proceeds, and they will pay the water bill. which is, if it's a 30-day water bill, it might be like $5 out of the $300. So the seller is going to be refunded like $295 or something like that. Okay, number 10, title evidence and survey. Seller agrees to order title insurance upon acceptance of the offer and to furnish buyer a commitment of title insurance to be issued without standard exceptions. Buyer to secure and pay for a survey if required. A title company to remove the standard exceptions. After closing, title policy insurance at seller's sole cost without standard exceptions will be issued in the amount of purchase price. And you can read the rest. What does this mean? The seller typically in a transaction will pay for their own insurance policy, and the buyer will pay for their half of their insurance policy. There's going to be a lender policy and a seller's policy. And so in Michigan, every single title insurance policy is the same amount of money. There's a schedule of, there's a list, and depending on the price of the house, of the contract, amount of the sales price, there's a certain amount of fixed ratio that the seller and buyer is going to pay for their insurance policy. So the only time it's beneficial to shop around title companies is if maybe the closing costs for the title company itself, like the closing fee is smaller. But we work with a specific title company that gives us great rates for our clients. And pretty much, we have all those resources that we use. So basically that's what that's saying. And title insurance has been recommended by the real estate broker. So we'll recommend like a good company, which is ours. Title objections. If objection to title is made based upon written notice, the title is not in the marketable condition required for performance hereunder, seller shall have 30 calendar days from date notified in writing of particular defects claimed to either remedy the title, obtain title insurance satisfactory to the buyer, or buyer agrees to complete the sale within 10 calendar days of written notification that the title has been remedied, or by date specified in this agreement if later. Okay, what does this mean? If there's a problem with the title, and I'll give you an example. I sold a house last year. The gentleman showed that on his property that there was a lien for a second mortgage for $25,000, something like that. I don't know the exact amount, but it was like $25,000. And unfortunately, the bank never filed the release of that mortgage from like the year 2000. It was like 1999 or 2000. And that mortgage company was out of business. They went out of business. They were bought up by one of those big banks, during the 08 and all that, the crash, all that stuff. So there's no way of getting hold of these people. We had no idea who had the record. So the title now is not marketable. The buyer or the seller cannot market the title. The title company cannot issue a policy because there is a lien on the property where there really wasn't. It was already refinanced years ago and paid off. So luckily, the seller, my seller, had in his file cabinet from like 20 years ago, or 15, 20 years ago, the actual lien release signed by the bank. So thank goodness. So that took us about an extra 10 days, and we needed to do an extension to close. And so, so he sent that into the title company. Title company examined it. They felt that it was not, necessary. It was okay. It was reasonable, and they issued the policy. So that's what that means. If there's a problem with title, you're going to have like 30 days. You can extend it. We'll change the closing date at the top with a thing called an addendum, and we'll extend it out maybe another 15 or 20 days, and then we'll go from there. Taxes, all property taxes due and payable on or before the date of closing shall be paid by the seller. What that means is there's a thing called a proration, and the taxes will be paid by the seller, up to the date of closing. So if it's mid-year, the buyer's going to have to pay the rest of the taxes going forward. There's a certain proration. The title company usually deals with the taxes. There's a formula for that you can compute. I don't. In this video, we're not going to talk about that. But the taxes will be calculated by the title company. But there's other ways of doing it. You can negotiate where the buyer pays all the taxes. Maybe it's an investment property, and the buyer has to pay everything up front. It's a bank-owned property. Usually bank-owned, they pay the taxes, so there's no problems. It's free and clear. Assessment, same thing. Seller shall discharge in full all public authority charges confirmed by municipality or taxing units, special assessments, sewer paving. So if there's a sidewalk, that was recently redone, and let's say it's for 1 year, the assessment. It's like $30 a month on your taxes. The seller will pay for $30 of that up for, let's say they had it from January to mid-year. January, March, April, May, June. So June. So let's say June of whatever year. They will pay $30 up to that year. However, since the purchaser is moving into the home, they will be responsible for those 6 months going forward out to December. Because the seller no longer lives there, it will be the buyer's responsibility to pay that. So a buyer is responsible for other assessments, including but not limited to capital and lateral charges assessed. You can read the rest of this, but assessments will be paid fairly. There are some assessments where maybe perhaps that the seller will pay in full. It depends on the situation. And again, if somebody has a comment, or if I'm, if there's something I'm missing, feel free to comment below and let me know. I can take criticisms. But assessments are definitely something that needs to be carefully looked at and made sure that it's paid upon closing. Same thing with condominium, number 14, condominium homeowners association assessments. The seller must pay and be up to date on any delinquent assessments from the homeowners association at closing. So basically, they'll take that out of the proceeds. The title company will get a letter from the condominium association. If there's something due, then it'll have to be paid at closing or before that. But the condominium or the title company will need a letter stating that they're in good standing with the association before they closed if it's a condo. Maintenance of property simply states that seller is responsible for keeping property in substantially the same condition as the date of agreement. That's basically what it means. You can read the rest of this, but the seller needs to keep the property maintained and up to date. Number 16, utilities. Seller shall order final bills on all utilities, water, gas. Now, water bill. Do not let the other agent take control of the transaction. As a buyer's side, your buyer, when he buy the house, if the water bill is not paid, and somebody forgets to do something and order a water bill and the seller never pays it, your buyer is going to end up paying it. So if it's a large water bill and say something crazy happened, there's a family, the family that moved there the last month, they let their aunts and uncles come over and use their washer and dryer. They ran up a $100 water bill, which is an extreme example, but it could happen. If the purchaser doesn't get that paid at closing to order a final water bill from the city, the buyer could be responsible. So simply, you're going to order a final water bill at the city for the day of closing. You're going to call them up, say, hey, I need a final water bill reading. And then, now some cities are very difficult to get one. There's forms you have to fill out. So if it's like a $10 water bill, sometimes it's easier just for the buyer to pay it or the agent to say, listen, I'll pay the $10 and close it. But ultimately, when the seller leaves, the water bill is attached to the address, not the seller. Except in some cities, it is attached to the seller, so it just depends. But from our experience in Michigan, mostly it's attached to the address of the property. So anyhow, just make sure that the buyer's agent, if that's you order the final water bill, or make sure that it's been ordered, even though this says the seller shall order the final water bill and utilities. Gas, electric doesn't matter. That's in the individual's name. If they don't pay that, that's their problem. But you want to make sure as the buyer that your utilities are on in your name and that property switched over on the day of closing. Because if it was my client and I'm on the sell side, I'm the listing agent, I would advise my seller to turn off those utilities immediately on the day of closing. So there's no, the buyer's not using another person's utilities on their account. Risk of loss, seller is responsible for any damage to the property except for normal wear and tear until the closing. Again, this is page 2. They'll initial that here. Okay, page number 3 of the purchase agreement. Seller's disclosure statement. As you may or may not know, each seller in the state of Michigan needs to write a disclosure out, and we'll go over that in another video. Disclosure will state to the buyer, seller's best knowledge of what is the problems with the house, if there's any. Now, it's between a buyer and a seller, this disclosure. Agents are not supposed to be telling their clients how to fill out the disclosure, no suggestions, because this is strictly between the buyer and seller. If the seller is lying, there could be a lawsuit, and everybody's going to get sued no matter what, including the agents. But in the end, if the agent has nothing to do with this disclosure, pretty much there's not going to be any problems on the agent side if the seller lied about it. There's something in there. So the buyer will initial A with disclosure they received it. Lead-based paint. Any house built prior to 1978 could contain lead-based paint. You're going to say that the buyer acknowledged there's a disclosure that's usually downloaded or filled out by the seller. It has to be available. If they want a 10-day opportunity to do a check, paint check to make sure that there's no lead-based paint inside the home, they can do that. 90% of the time, nobody does that unless they have very small children with maybe some medical problems. They have to absolutely be sure there's no lead-based paint. But I mean, in general, lead-based paint is very bad for anybody. It doesn't matter if they have good health or not. So, but if they waive it, they're going to initial C. Buyer hereby waives an opportunity. Okay, number 20. Buyer in the event buyer fails to fulfill obligations set forth herein or fails to close this transaction in the time and manner provided, seller may elect to enforce the terms and declare the sale void and retain the earnest money deposit for liquidated damages. What does this mean? Okay, this is very important to understand. I'm going to go slow on this. If you have an agreement on a property, PA, sign, and you get through your inspection, which we're going to talk about down here, your 7-day or 10-day inspection, and you get done with the appraisal process. Pretty much after the appraisal process, there's a very high probability the house is going to close. Nothing matters until closing though. Never assume the house is going to close unless it closes. Don't think it's in the bag. Yeah, I got, the money's in the bag, the commission's coming in, I'm done. It's not done until everybody's at the same table signing the paperwork. So keep that in mind. If the buyer backs out sometime, let's say it's 4 days before closing, the buyer says, hey, I don't want to close, I don't like the house anymore, they don't show up to the closing. There's a couple remedies that the seller has. Number one, the seller can sue for what's called specific performance. So what that means is a court will say you are going to have to perform and be forced to buy the home. You're approved, you're about to close, you have to buy at this point. Say the seller's moving out of state, they have to have the money, they may have to sue. Or the seller may say, hey, I want the earnest money deposit, which was up here, the $2,500 that we had up here. So that's why it's very important to have the EMD held in the brokerage escrow account at your brokerage company. Because the seller might say, hey, I want that money. If it's not there, there's a law broken. It's very serious. Okay, so the other thing is in the event the seller fails to fulfill she's obligations to close the transaction in the time and manner provided, buyer may elect to enforce the terms or declare the sale void, be entitled to a refund of the EMD and or seek available legal or equitable remedies. So if the seller at the last moment says, oh, I don't want to sell now. We just had a new baby and I want to raise the child at this house and we're not selling 4 days before closing. Obviously, the seller or buyer is going to get their money back, their EMD it's called, or they can sue for specific performance that they are going to buy that house and the seller must sell, or all of the above, or they can sue for additional funds. Maybe they had to take days off of work. They missed, who knows? It cost them $2,500 to buy this house. And in regards to like taking time off of work, maybe they canceled a job. So there's a lot of things that could happen. So be very aware of that and make sure you have good qualified people you're working with. Fees. Our company charges a compliance fee of $299. That's every major broker firm that I know of has some type of compliance fee, and they were from $200. I've seen them as high as $600. This is a compliance fee. There's a lot of administrative costs that a brokerage firm goes through. There's a lot of storage for the state of Michigan. We need to keep files hard copy or electronic for 7 years. This is what that fee goes towards, and every single brokerage that I know of has it. I can't say everyone has it because that's a thing called price fixing, but I can tell you that from my best knowledge, everybody I've dealt with so far has a compliance fee. Okay, number 22, time limit. The most important thing here is the time limit as well. Very important. Always, always put a time limit in your offer. Always. Here's the reason. We're going to make this offer for, excuse the date here, but let's just say the date was 11. We're going to give them till the 5th, which would be tomorrow at 5 p.m. Now, what does this mean? Why is this so important? If I don't put a time limit in this agreement and I submit this offer today, and 5 days from now, my client decides to buy a different home. Oh my God, I love this house. We put money down, signed the PA. Everything's locked in on another house. This seller might come back and say, hey, I'm accepting your offer today. And now you're going to be put in a complicated situation where you're going to have to figure out what to do because the seller accepted it. And if you back out, there could be problems. Of course, there are ways of getting out of it through the property inspection, which we're going to talk about. So if it's a cash deal and there's proof of funds on both sides, say the investor waived their inspection, then they could be sued for specific performance. That this seller might say, hey, you're going to buy my house. And now you have the other person saying you're going to buy my house. So just don't be put in that position as an agent or individual. So put a time limit in, because if they come back on that Friday and say, hey, I accept your offer, you're going to say, hey, Mr. Smith, I had a time limit of 5 p.m. So the contract now is void because they accepted it past 5 p.m. Now that doesn't say that you can't accept the offer still. Maybe you didn't find a house and you really wanted that home and they came through. The seller said, hey, I'll accept it. That's a good thing. You can still accept the offer, but it's just mostly a protection for the buyer is really what this is right here. And if you're a good agent, you know what you're doing, you put in that time limit so you're never locked in. 23 additional addendums. We're going to talk about addendums in another video. Guys, please put your correct addendums in. If you're doing an FHA loan, put that in there. Don't be lazy and just not put an addendum in there. Just, put an FHA indication up here, but not use the addendum. Putting FHA here, but not marking off that you have an addendum and using it. Please use your proper addendums. It looks professional. It is professional. And if you don't have them, and the buyer may not understand and know that you need an addendum, you are going to get the buyer locked into something and they're going to be very mad if something goes wrong. So please put your addendums in, whatever it may be, well and septic addendum for those purposes. Number 24, flood insurance in Michigan. We don't have that. We put 0 and 0. By the way, in a contract, never leave something blank. Never leave it blank. If it's like if you don't have anything in here, you can put 0. If you have something blank up here, like per day, if it's at closing, put 0. If it's possession at closing. So don't leave a purchase agreement blank because people can fill that in and change it. So always put something in there. Number 26. Very, very important. You can read this on the screen here. This is an inspection clause. What this means is that on the day of the offer, if it's accepted, say it's accepted today, November 2nd, technically speaking, from this time on, from 7 days, the buyer has 7 days to back out of the transaction if they don't like the inspection on the property. Sometimes this is 10 days. Industry standards is usually 7 from my experience. It could be 10 if it's over a holiday weekend, like a Columbus Day or something. Now, if your buyer goes into a property, they're going to initial first down here that they do want an inspection. You can look through this and read this clause while I'm talking and understand. So, if they back out, they don't like, I don't care what it is, what excuse. If they don't want to buy the house because they just don't like it, there is no explanation needed by law to tell the seller why they're backing out. They can send in what's called a dissatisfaction addendum or dissatisfaction notice. And as long as that gets sent over in writing within that 7-day period, the seller cannot do anything. The deal is, the transaction's void. It's done. So you got to make sure, though, if you're an agent and you have a client that backs out, you do it within this time frame. Even if you can't get them to sign an addendum, as their agent or individual, make sure you email in writing. Email, not call on the phone, not fax. You want to email everything for a timestamp that they're not satisfied. So in the subject line, dissatisfaction of inspection will be in the subject line. And then Just in there, hi, my buyer has decided to pass on the property. They are not happy with the inspection, period. If the seller pushes you or the other agent pushes you for an explanation of why, they don't need one. It's not their right. You don't have to give them an explanation. You don't want the property. You didn't like the inspection. Listen, if it's a bad house and they know it, believe me, that listing agent knows what's wrong with that house. They know why it didn't pass inspection. The whole basement's cracked. They knew that. Maybe the seller hit a crack in the basement, didn't tell anybody. And the listing agent found out from a previous transaction that didn't go through. Well, he knows now why it's not going through. Liability of buyer for damage. When the buyer goes through the inspection, they're liable for any damage they do to the house. If they want to tear out a wall to do some mold inspection, first off, you can't do that to someone's nice house. But if they have to put a tiny hole to send a camera in there, they're going to have to pay a licensed contractor to go out there and fix their wall if they don't buy that house. So you can't, damage someone's home during an inspection and not fix it. That's what that says. They're going to get sued in court if they don't fix it. They could. Municipal inspections. Sometimes there's inspection fees with the city. For example, some cities require a letter of transfer for an inspection or a C of O, list or something, a letter to allow the transfer of deed. Sometimes that could cost $100, $50, some cities, whatever. Usually the seller will pay for that because if they have to pay to get that inspection done in that letter, the buyer shouldn't pay for their inspection and letter. They're going to have to do it no matter who buys the house. So usually that's on the seller to pay for those type of fees. Now, to pay for the inspection and the appraisal, the buyer does that. The seller doesn't do that. But if it's anything that sticks with the seller, that's going to have to be done and paid by the seller. 29, as is condition. Obviously, you're buying a house as is condition. Time for legal action. Basically, this is buyer and seller agree that any legal action against either party or against broker or their agents related to the condition of the property or arising out of the provisions of this agreement or any services rendered or not rendered must be brought within a short of the time provided by law or 1 year after the closing. So what this means is that, without reading verbatim here, if the law states they have to bring a lawsuit within 6 months, then the law obviously supersedes this contract no matter what. The law always supersedes everything. If the law says they have till 2 years, then it still supersedes it. Or if the law says 1 year, then you have 1 year. So that's what that means. Showings. Seller agrees not to allow the property to be shown after the inspection contingency is removed. So let's say your inspection took 1 day. You did it the same day or the next day. You can send in an inspection contingency removal addendum to say, hey, I'm good. Let's move forward. No more. We're not going to wait 7 days. We're moving forward now. And once that's done, the seller cannot show that property again. However, in the real estate world, once you have a signed offer, you are supposed to mark the house pending on the system, the MLS system. And ethically, you don't show the house again. It is under that status. And there's no sense of doing that. And that makes people very upset, makes agents very upset when you play games. Just be ethical and mark it pending upon, both parties signing the purchase agreement and everything, is solidified there. 32, foreign investment in real estate tax act. This is a government thing. If the sale price exceeds $300,000, the title company will handle that. There's just they have to fill out extra paperwork. There's extra requirements. So for that, if it's someone from maybe from China, there's a lot of people actually coming out from different countries buying properties. Number 33. You can read this again. This is just a legal document binding everybody. They acknowledge that they have been advised to consult an attorney for things. We are not, as agents, or an individual buyer, if you're not an attorney, do not try to give people legal advice. Do not try to give people tax advice. If you're not a CPA or a licensed attorney and belong to the bar with the state of Michigan, do not think you are if you have all this knowledge, you want to give it to people, don't advise them. Tell them to talk to their own advisors. You will have a problem legally if you give someone the wrong advice or you're trying to act in the capacity of an attorney. You are not counsel. Don't do it. It's not advised. If somebody asks me a legal question that could get them sued, I would tell them you would have to check with your attorney on that, except if it's something that I definitely know that has to do with real estate, like the inspection, that I know for a fact they're not, they can get their money back if they cancel the void of the contract, if they turn in the inspection addendum, dissatisfaction addendum. So just, don't give CPA advice or legal advice or any of the above. This is just a disclaimer of brokers, for example, that we're not responsible for the condition of the property. So here's what this, and you can read this as I speak again. What this means here is that as a broker, please make sure your buyer does their own due diligence as well. You can call the city, you can provide them information, but at the end of the day, they need to know what they're buying. So for example, if you call the city and John answers the phone, say John's not the greatest employee with the city. John says, yeah, you can convert the house into an office. It's off the main road. You can convert it because the zoning allows it. Okay, you tell your client that and they buy the house based on your recommendation. This says you're not responsible if they find out in the end that they can't do it. However, you're going to get a bad review. They're still going to get sued, and there's going to be problems for nothing. So in this case, what you do is, let's say John got fired from the city the next day, okay? You're going to tell your client to call the city as well directly to verify the information. Here's what I discovered for you. It is zonable, but I would like you to, and put this in writing through an email, that I would like to advise you to call the city directly in case I did get the wrong information. You don't want to be responsible for somebody making a huge mistake like that, okay? So just make sure, even though we're not responsible as agents, technically, we want to be professional and make sure that the seller or the buyer absolutely knows it's their job to make sure they know what they're buying. Final walkthrough, 48 hours. You call the other agent, like to do my walkthrough. It has to be done. They have to let you in. Entire agreement. That just says that, that's an entire agreement. You can read that. Time of the essence, standard clause. This agreement shall bind the personal representatives, administrators, successors, and assigns all parties. Facsimile, electronic authority. Once you sign this, purchase agreement states that you can do like Authentisign, which is electronic signing through email, and you can fax and all that. This is what this means. You can read it later on. Miscellaneous, number 40, amendments, headings. This is just all basic, stuff in a purchase agreement. You can read this in a minute or as I'm speaking. Other terms and conditions. Here we go. So, what does this mean? Usually this is on a separate addendum, but this is where you're going to write in your concessions, your special things like seller shall pay for home inspection, or seller shall pay for home warranty. Seller shall give a credit. So seller shall provide buyer with concessions up to $5,000. So what this means is that, for example, what are concessions? Well, that's another topic, and it's going to take too long for this video. But concessions are a credit to the buyer upon closing from the seller. So, quick example, if you're buying a $100,000 home and the seller is going to provide concessions, which is going to give the buyer $5,000, and you want to add in here up to for closing costs and prepaids. So what that means is that if the seller has their down payment, say they're doing FHA 3.5%, but they need $5,000 for a down payment, but the closing costs are going to be $4,000. And I don't know if that example is perfect or not, but just bear with me. The seller is going to provide $5,000 at closing, so they only really need the down payment. And so they can still get into the house because the taxes and the other things will be prepaids and closing fees will be provided by this. Now the buyer's going to have to pay for probably their appraisal up front and their inspection, which is going to be like $600-700. They're going to need at least that and their down payment. So that's a given. You have to pay for that, unless the bank or the mortgage company works something out, and they might help you out as well. You can get a lender credit as well. They can give you money back to get in. There's a lot of things you can do. So if you're working with an experienced professional, you can do a lot. If you're an individual buyer, you don't need the full amount of money to get into a house. You can get concessions and only come up with a down payment. There's ways of writing this purchase agreement up that that helps you. So that's what that means. Special terms. If it's longer than that, you're going to get an addendum, and then you're going to put those extra terms on that. So, okay, now finally, page 5, buyer signature and acknowledgement of receipt. This is where the buyer is going to print their name and sign. Same thing here. You're going to witness and sign and put the date as agent. Now, here's what we talked about, the debate in the industry about the bottom line, which is the buyer acknowledgement of acceptance, and this. If the seller signs this right here, prints their name, signs on the line, and the date is November 3rd, technically this is a binding contract, this whole thing, because the seller did accept and the buyer signed. But industry standard states that once you get that, you want to send back the bottom line. Get your buyer to sign it the same day if you can. Not the next day. Don't let it go more than one day, because you want to get this date very close to this date, just to be sure, preferably on the same date. Now you don't have to worry about this line compared to this line, who signed when and how, because that 7-day inspection period that's up here is going to correlate with this date here or this date here. If this date and this date's both the same, you don't have to worry. If this date here is the 7th and this is like the 15th of the month, you are going to have a problem. You're going to want to go with this date. This is going to be more important than this date. And this could be a debate in court. If you go with this date and sign this 20 days later after this, and they use this date for their inspection, the seller's going to say, oh no, we signed it on this date. So just be aware of that. But there is a debate in the industry which date is important. So what I train agents to do is to make sure this is on the same date. That's all. Date it the same, and all these numbers up here will correspond. You're 30 days out from the closing day. So technically, 12/3 is the closing date. Say it was accepted on 11/5. You need maybe, an extra 10 days. You're going to write an addendum. There's a whole bunch of stuff that could happen. But for this purpose here, again, I can't stress enough, make sure those two dates are the same. Okay, so I hope this helped somebody out there on what a purchase agreement looks like, how to write it up. It's very simple in the end, but make sure you have these inspection periods in here. Even if you're using a non-standard form, a for sale by owner, make sure you have your inspection clause. That's very important. And make sure it has your appraisal clause. If you can't get a mortgage, there's another portion up here. If they can't get a mortgage based on the appraisal didn't come in, that could void the contract, and the buyer should get their EMD back. So again, thank you for watching this video. I hope it wasn't too long. And if you have any questions or concerns, feel free to comment below. If there's something that's incorrect, feel free to criticize and leave all the comments you want. I'll be happy to look at everything. And I'm always open to new ideas from other agents. But again, thank you for your time, and have a great day.